All right, welcome to the Yeoman Podcast. I'm your host, Geoff Graham. Excited to have with me today Ari Bargil, the senior attorney for the Institute for Justice, and also the co-director of the Zoning Justice Project. And I also have with me my brother, Vince Graham, brother and business partner with the Ion Company. Vince is the owner of Loci, a developer in the Charleston, South Carolina area, and an aspiring civic artist, I think. Is that how you would describe yourself, Vince?
Yeah, that's right.
All
Thank
right.
you, Geoff.
Ari, did I get that right for you?
Nailed it.
Well, thank you both for joining me. I talk with people about the topic of zoning a good bit on the Yeoman podcast, and the general sort of theme for Yeoman is what in what ways do small businesses, artisans, craftspeople, entrepreneurs, in what ways do they find opportunity and build things, grow things, create things? And then what are some things that hold them back? Like, what are the institutionalized forces in our society that are, say, tilting the playing field against the little guy and tilting it in favor of bigger forces, or tilting it away from beauty, craftsmanship, art, and so forth. So when people are like, Geoff, why do you care about zoning? Or why is it a big deal? I'd say it's this thing that is all around us that has been with us for, more than approaching 100 years now in the United States. It's this thing that has this subtle regressive force in our society, and it impacts us in all kinds of different ways. I was excited to talk to Ari. It kind of queued up the conversation. Got teed up after I listened to a recent podcast, the Tom Woods show, where Tom Woods, who's kind of been around for a long time and a libertarian type. Well, I would say not type, but a libertarian who thinks about all sorts of things. He seemed to have come across the topic of zoning relatively recently, which was a surprise to me, and had a deep conversation with a great guest. We'll link to this in the show notes. And kind of the scales fell from his eyes about the impact of this. And his assertion in there, he echoed his guest's assertion, was that that zoning in America might possibly be even more damaging to us as a people than war. A big claim. So with that, I'll tee it up, and my first question we'll tee it up with a question for Ari about, hey, can you share sort of what the landscape looks like from a legal perspective in the zoning world right now, and maybe how has that changed a bit since you began your career?
Sure. First, thanks for having me. As you said, I'm a senior attorney at IJ. I'm the co-lead of our Zoning Justice Project, which is a campaign in the court of law and court of public opinion to restore the right to peacefully and productively use property. And I think your question goes to that. Over the last 10 or 15 years, I think the conversation has, for the most part, been changing in the public sphere. I think that courts generally tend to be a little bit downstream of culture and legislation. And so, when I was in law school eons ago, but 15, 16 years ago, the understanding of zoning was that it was this weird thing that really only mattered if you wanted to, do these really big projects and you needed government approval for, some massive dig or something like that. And that just was never true at the time. And it's definitely not true now. And as we've come to talk more and more about it, as the housing crisis has gotten more and more acute, and as people who are my age and younger are getting out into the workforce and trying to find housing and realizing how expensive it is, people are starting to ask questions about, well, what's really behind this and what can we do to change it? And that's where zoning invariably is starting to come up. You're seeing a lot of action in state houses, and a lot of bipartisan reforms, which we can maybe talk about later. And I think the next phase of that, as you alluded to, is going to be in the courtroom. So far, zoning is pretty entrenched. It starts with Euclid about 100 years ago. But there are ways to start nipping at the fringes before going after the big wins. And that's what we're doing at IJ.
And you've had a number of big wins. Can you share some of those highlights?
Sure. So zoning isn't just housing, it's small businesses, it's charities. It implicates, unfortunately, everything, that we do for the most part in terms of where we live, work, and play. And it's all around us. And so, in South Fulton, Georgia, we represented a woman who wanted to open an African hair braiding salon and was told that she couldn't obtain a conditional use permit, even though she was eligible because there was, a neighboring salon that was doing something similar, and they didn't want two to be close by. So they wanted to shut down the small business before it ever even got started. We jumped in and we got the court to say that that's an illegitimate use of the zoning power. You can't wield it as a way to restrict competition or to pick winners and losers in the marketplace. A couple weeks after that, we got final victory in Kalispell, Montana, on behalf of a homeless shelter, where they had received a conditional use permit 2 years earlier, and then a local government, having become dissatisfied with the shelter, threatened to take it away. We went into court and we defended the property interest of that homeless shelter to be able to continue its operation after adducing, a vast amount of evidence to show that everything that the town was suggesting about this homeless shelter being a negative impact on the community was incorrect and false. And those are the types of challenges we're bringing right now. We've also got a case in Calhoun County, Georgia, on behalf of a woman named Cindy Tucker, who wants to build a tiny house village. These are cottages. It's really a cottage village of about 1,200 square feet and under, but she can't because of minimum square footage requirements for the homes that she wants to construct. This is just economic elitism in disguise, telling someone that they can't build something that's more affordable for them because you don't want low-income people in your community. Those are the types of cases that IJ is bringing in all of those different areas: small businesses, housing, and charity.
Can I challenge, this might be difficult for you, but could I challenge you to steel man the argument for that latter case? Like, why ought a municipality be able to prevent someone from building a 1,199 square foot home?
So usually the way they do this is they try to concoct, and this goes all the way back to Euclid, some health and safety justification. Because when you go into court and you challenge these things, the only thing that the government really needs to do is tell the judge, well, this is kind of loosely connected to this legitimate interest we have in protecting health and safety. They don't come out, they rarely say the quiet part out loud, which is that we don't want people who don't earn X amount of dollars living in our community. And so the way that you do it is
an interesting thing that they don't say out loud, because the Euclid opinions pretty much said that.
It does. And I hope we do get to that. But in a case like the one in Calhoun County and anywhere else where you see these types of restrictions, which are nakedly designed, in my view, to keep out a certain type of person, you'll say something like, well, we think that if somebody's building a more affordable house, it's conceivable that they're going to cut corners on building materials. And so these won't be safe because they're not going to be using the type of materials that we like. Or, if you're under a certain square footage, maybe you're not going to be totally to the international building code. Things aren't going to be attached with, concrete footers in the way that we want, or rooted to the ground in other ways. And then you tie that to some local environmental or a climate concern. In Florida, you say these will blow away in a hurricane. Maybe somewhere in the Great Plains, you'll say these will get tossed around in a tornado. And there's your, conceivable government interest. And sometimes that's enough to win the day. So when we litigate these cases in court, we're not just battling against what would appear to be the superficial stupidity of the regulation, but we're also battling against the highly deferential standards that courts apply when considering these challenges.
And the sentiment, it would seem to me that, so firstly, the Euclid decision, the 1926 Euclid versus Amler decision, did it was the decision of the courts that municipalities could make decisions like that were, blatantly elitist. They had the power to do those things. Am I interpreting, is that a fair way to describe it?
I think that's right. The silver lining to Euclid is that some of the worst language about, pig in a parlor and apartments being parasites that, leech off the goodwill of the single family neighborhood. I think you can fairly say that that's the dicta of the court, which is a way of saying it wasn't central to its holding. What the court was really addressing in Euclid was whether they could zone, and in particular, in that case, an industrial property, to residential. And the division between single family and multifamily, I think, isn't something that was directly in front of the court. That's how I would characterize the Euclid holding. But it is problematic nonetheless that the court singled out single family and multifamily as being two things that, aren't necessarily compatible uses, because that's really what Euclid was addressing, was whether this is really just a way of dealing with nuisance, and calling us a multifamily use a nuisance to a single family one, I think, is inherently problematic regardless of the context.
Something I've wondered about is, why didn't the court at the time, when it was thinking about things as nuisances, why did they make the decision that a municipality may establish what may or may not be done on a piece of land, rather than try and clarify what obligations a property owner has to prevent contamination or damage to his neighbor's property? Like, that would have seemed like the more reasonable way to go about looking at, how people use their land.
So I don't really know the answer to that. I think in part it's probably because of the way the question was presented to the court. The locality passed this regulation saying this is how we intend to essentially proactively regulate nuisance in our community. And the court had to answer the constitutional question of whether that was legitimate or not. And courts rarely, I think, are going to go so far as to say, well, there are these other common law doctrines. I mean, they could. There are these other common law doctrines that work better. But usually when the government starts suggesting things that work better, you're dealing with something that's called heightened scrutiny or strict scrutiny. And this is, again, when I talked before about the legal standard, this is where that comes in. Because in Euclid, you have this iteration of the rational basis test or substantial relationship test, which is what they called it there, which says we're not going to get into whether or not you're doing this using the least restrictive means or the most sensible regulatory approach. We're just going to ask, could you conceivably do this, given the asserted interests? And just like in the hypothetical situation that I described in Georgia, court in Euclid says, well, here are some of these things that the government might have been trying to accomplish. And of course, this is somehow better for the children, which it mentions a few times, and signs off on it and says, well, there's a substantial interest here. This is at least related to a substantial interest in some way. And so who are we to decide, there's all this, zoning is a new thing. It seems to be necessary in light of the, exploding populations, and urbanity is growing and we don't know how to deal with it. And it's not the job of the courts to decide, these big questions, which is a major departure from what the courts had been doing up until that point, which we can get into if you like.
Yeah. Can you elaborate on that?
So are you familiar with the Bettman brief?
Mm-mm.
Okay. Vince knows about it. Geoff, your head's going to explode. So this is, Euclid is decided in 1926, which is an era of the court described by some as the Lochner era, which was characterized by the Supreme Court striking down as unconstitutional a lot of progressive and New Deal era legislation. It led to threats from the president and other progressives to pack the court. And one of the quote unquote four horsemen of that era, known for striking down legislation after legislation, is Justice Sutherland, who's the author of the Euclid decision. And so you would think, or you might have assumed, that in that era, a justice who was so closely aligned with a core group of justices that was striking down federal overreach, you might think that in that scenario, or in a similar scenario where property rights were at stake, the court would also have been just as inclined to strike down something like zoning. And in fact, it was very close to doing that, Geoff. Euclid was argued twice before the U.S. Supreme Court. It was not just argued once. It was argued, I think, in November and then again a few months later. It was argued in June and then again in November. Justice Sutherland did not participate in the first oral argument, and it seemed like the court was poised to strike down zoning in Euclid the first time after it was argued. Now, there's this fellow also from Ohio, named Alfred Bettman, who's a lawyer and a planner, and happened to count amongst his close friends a gentleman by the name of William Howard Taft, former president and Chief Justice of the U.S. Supreme Court at the time. It's not clear whether he just blew the deadline or decided after the fact that he wanted to submit an amicus brief, but he wrote a letter to the court saying, I'd like to submit an amicus brief to assist the court with its consideration of the case. The court agrees to let him write his brief. He is also associated with the Standard Zoning Enabling Act and Herbert Hoover's efforts to push this down into all the states. He's the first head of what became the American Planning Association. They celebrate this man for the work that he did to establish zoning throughout the 50 states. And he gets his brief into the court after the case is argued. The court decides to have re-argument, and lo and behold, after that brief is filed, re-argument is heard. The court upholds the zoning restriction in Euclid and forever alters the course of history. And if you look at Bettman's brief, that's where you find some of that pig in the parlor parasite language. So it's no doubt that the Bettman brief had significant influence in the court's decision in Euclid, and perhaps moved it off of what was its natural trajectory at the time of striking down legislation. And that makes sense when you see what the court did a few years later in Nectow v. Cambridge, which we can also talk about if you're not familiar with that case.
Well, I do want to hear about that, but can you describe how the Euclid case came before the Supreme Court, and what did the lower courts take on Euclid? What was that?
Sure. So the Ambler Realty Company owned a tract of land in Euclid, Ohio. And the town was concerned, it said, with the encroaching industrial development that was surrounding it coming out of Cleveland. And to combat it, it decided to zone. And this is in the early 1920s, when zoning is still a very new thing. You only have a handful of localities throughout the country that have really adopted it. And it zoned not just industrial property.
There had been attempts prior that were struck down that were sort of race-based zoning.
That's right. So you have Buchanan v. Worley in 1917, which was just a naked restriction on persons of one race selling to another race. And the court struck that down. And then, not surprisingly, these things got a little bit more complicated. I should say the zoning ordinances got a little bit more complicated, perhaps with an eye toward accomplishing the exact same end goals, but using different means. And so the town of Euclid passes its zoning code, separating the town, I think, into like 6 different tracts. And the Ambler Realty Company said, well, we've got this tract surrounded by industrial uses. It's only really good for industrial use. It's not good for residential use. And you've zoned us residential. And, that's a violation of our rights. And the specific claims they made there weren't so much that it was a taking, but that it violated the Due Process Clause and Equal Protection Clause of the Constitution. And the lower court agreed with them. They said, this is not legitimate. You're putting all of this property in a straitjacket. It's, reducing the usable value of this land. And if you have a right to own land, you have a right to use it consistent with its surroundings. That's all these property owners want to do. And for government to step in and say, you can't use your property in this way is unconstitutional because it's illegitimate. It's disconnected from any legitimate government goal. And that's what went to the U.S. Supreme Court. And the U.S. Supreme Court basically said, well, we're not going to look that deeply into whether it's going to accomplish the goal or not accomplish the goal. We're just going to ask whether it's conceivable that government could have an interest in doing this, whether or not health and safety is somehow implicated here in a way that government intervention is warranted. And having found that, we're going to say that there's nothing, constitutionally impermissible with what the town of Euclid wanted to do. It comes back to that standard. It's really a matter of what is the standard, because we'll talk about Span v. Dallas, which came before, and which the Supreme Court in Euclid distinguished. But where the courts have decided we're actually going to look and see whether or not health and safety is implicated here, and what the government is doing is actually promoting those ends. When the courts take a close look at that question, those restrictions tend to get struck down, or at least did. But when the courts were taking a very hands-off approach and saying, well, we're just going to defer to the findings of the experts and local government on this, that's where you see these ordinances being upheld nationwide. And that's the approach that the U.S. Supreme Court took, which trickled down to the states and state courts and lower courts.
Just one interjection to underscore Professor Bargil's constitutional law class, which is really good. I'm enjoying. But that lower court, the federal court, and the Euclid v. Ambler case, David Westenhaver in 1924, ruling for Ambler, he in that decision, he recognized Euclidean zoning as a system designed, quote, to classify the population and segregate them according to their income or situation in life. Close quote.
Yeah, he acknowledges that everyone's living arrangement is just a truism, that your living arrangement is typically a direct reflection of your socioeconomic status, and that by regulating how and where people can live, you're necessarily restricting and segregating people by income. Absolutely.
So that was 1926, a very different time. That same court, I think in the same year, did they uphold Buck versus Bell? Is that right?
I'm not sure if that's the same year.
Yeah, it's the same court. It's within a brief period of time.
Yeah.
That decision was that a state may forcibly sterilize a person.
Yes.
It's just like we look back at some of the things that were happening during that time, and it was a wild time in America. Yeah. Like tons of things changing, all sorts of political philosophies like emerging and blossoming and then collapsing, and it's a wild time.
I will say I think that's a good sort of touch point to unpack a little bit, because wild is one way to put it. I think in hindsight it was terrifying, because there was this feeling, mainly amongst the progressives, that like we could build a utopian society.
Yeah.
Eugenics were definitely a component of that. But so too was this sort of technocratic, expert, driven and scientist driven approach to planning. And there was this belief that not only could we create, and engineer the perfect, race of humans, but we could also design, communities and cities and neighborhoods from the top down. We have the expertise now. The science is in, the sociology is in. We know what's best for people. And that mentality pervaded a lot of the policymaking of that era.
Absolutely.
Looking back 100 years later, I think some of that stuff fell out of favor very quickly because, of things that happened in Europe not long after, which showed it for what it was. But just, looking back 100 years later at the hubris of that era and the belief that we could, engineer a perfect society is just terrifying. You see some of it now, but not, thankfully, I don't think at the federal level in government.
And yet, this zoning was one of the things that came out of that, a reflection of that faith and technocratic central planning. And it became institutionalized. And so it is with us, like it's this residue from that era, which was really terrible. I mean, I say wild in the sense that it was such a dramatic change, but I agree with you in that it was terrible, but it's this residue that is still with us. But what was so contrast that with the court today. Like, if Euclid were to come before this court
on a blank slate,
without, we have, of course, 100 years of history of it. Some towns have 75 years or 50 years. I think I might ask you to explain the concept of stare decisis, which I think I generally know, but people have said are relevant. But we've had zoning for a long time. But if if we had not had zoning for a long time and it came before the court today, how do you think they would react?
So this court has indicated, through a series of opinions over the last, this court is shifting a lot, but in the last few years and just in the modern era generally, sort of a return to traditional understandings of property rights. An acknowledgement recently of the right to exclude, for example, an acknowledgement of, there are reasons to be optimistic. But if you look at like the Supreme Court's decision in Kelo from 2006, there the court upheld just the physical taking of private property for the benefit of a private corporate actor. That was a hugely catastrophic decision, one that I don't think really had too much to do with the constitutional history post-Euclid, and was really just a separate question about, public use, which is a requirement for a taking under the Constitution. So there's been a constant push and pull, and it's been this way throughout the course of Anglo-American history. What are the rights of the private property owner, and when do they give way to the public interest? I think our founders intended to account for that in the creation of the takings clause. But it's hard to really hypothesize what the court would say about zoning today, especially under the existing constitutional frameworks that exist for like due process and equal protection. I think if I came into court and said zoning is unconstitutional because it draws irrational distinctions, the court would say, okay, well, has a fundamental right been implicated? Or are any of your clients members of a racial minority or suspect class who have been discriminated against? And if the answer to those two questions is no, well, we're back down to the rational basis test, which doesn't, its origins aren't in Euclid. The rational basis test has been around for almost as long as Euclid and emerged out of that same sort of post-Lochner era of the court. But I think as long as you're coming into court and you're dealing with the rational basis test, and government is still able to get away with just, capacious hypotheses for what it's trying to do, it's going to be challenging to win. So I think that's the battle that needs to be won first, is getting courts to re-engage with hard constitutional questions, even when fundamental rights haven't been implicated, or at least getting the court to reconsider whether it makes sense to divide rights into rights that matter and rights that don't. But so there are broader constitutional battles going on that I think implicate that are implicated by your question that makes it really hard to answer. But I guess the long and short of my response is that I'm not super hopeful, but I do think it could be the sort of thing that gets upheld, but for different reasons or in a different way.
Can you explain the rational basis test?
So the rational basis test is the court's way of, and this is sort of, I'm being glib, but the court's way of addressing constitutional rights that it thinks are important. This kind of emerged out of the Caroline Products decision, which is a New Deal era decision upholding a government regulation. And what happened in that case doesn't really matter, but what emerged from it is this distinction between the rights that matter and the rights that don't. So fundamental rights are the ones that the court has said are going to receive heightened or strict scrutiny. And those are the rights, generally speaking, that are identified in the Bill of Rights and expressly enumerated in the Constitution. Once one of those rights is triggered or has been implicated, somebody who's going into court saying my, First Amendment right to free speech has been violated, or my right to a jury has been violated, these fundamental rights, if somebody's alleging that that's been violated, the burden typically shifts to the government. They've got to come into court, present actual evidence of what they're trying to accomplish, what's the government goal at issue here, and how does this law that's being challenged directly promote or further that government aim. It's really hard for government to meet that burden. And so when heightened scrutiny is being applied, i.e. when fundamental rights have been implicated, government often loses. The only other time, generally speaking, where that type of constitutional standard of scrutiny is applied by the courts is if you're a quote unquote member of a suspect class, somebody who's been historically discriminated against, racial minority, sometimes, gender or sex, to a certain extent. But that's pretty much it. And if you are saying, well, I've got my right to earn an honest living, or I've got my right to use my property as I see fit, to the extent that courts don't agree that those are fundamental rights, you're left in rational basis land. And that's where pretty much all of the litigation about, economic regulations and things of that nature take place. And so that's the rational basis in a nutshell. If you haven't implicated a fundamental right or a suspect class, you're going into court knowing that the deck is stacked against you, because courts don't even, some of them, feel like they need to weigh any evidence whatsoever. Government just needs to come into court and say, hey, here's what we're trying to do. And the court will say, well, is it conceivable that what they're doing is reasonably or rationally related to something that seems legitimate? And if so, we're going to sign off on it. It is a rubber stamp. It is a judicial rubber stamp. And that is, I think, probably one of the biggest barriers for litigants like myself, or advocates like myself, when we go into court to try to challenge overregulation, is the standard that the courts apply.
We have enough history now. This is a pivot a little bit. We have enough history now to make some assessments about whether or not zoning makes Americans healthier and safer, or whether it does the opposite.
Yeah.
And it would seem to me that the evidence is pretty compelling that it does the opposite, and has failed in its purported aim. I don't know if purported is the right word, because it was, at the time, pretty openly racist and classist at the time. Yeah. But I think the justification was health and safety. Is that right?
Yes.
So given that, or if one can successfully argue that it's failed in that regard, what does that mean? How does that impact the strength of the case against it?
So it could. So on the one hand, we've got stare decisis, which you mentioned before, which is really just a fancy Latin term that lawyers use to talk about, precedent, legal precedent, and maintaining fidelity to that precedent. And courts don't move off of old decisions very often and overrule themselves very often, absent a handful of, specific circumstances. One of those, though, to your question, is changed circumstances. It's not a super well-developed area of the law, but basically, and this is, sort of what undergirded the ruling in Brown v. Board of Education, which struck down, segregation in schools. There was a time where the courts swallowed this notion that it was actually better for kids to be segregated during their education, and that there was such a thing as separate but equal, and that separate, you could still have something separate that was still equal.
That was the Plessy.
Yes.
Yeah.
And in Brown v. Board, the court sort of acknowledges, well, that was just bogus at the time that it was announced, and we now have the data to back that up. And there are all of these problems associated with segregation that we can identify now that maybe we couldn't have identified earlier. And whether you accept that as right or honest is one thing, but there is precedent for this idea that once something is demonstrably bogus, it makes sense for the court to change its mind. And I think that could be the sort of thing that, one could maybe try at the right time in going after Euclid, because when you read Euclid, a lot of what the court seems to be saying there is, well, zoning is this kind of new thing. Places are adopting it. Early on, regulating urbanity and community was easy because life was simple and not so complicated. But now we've got cars and we've got pollution, and, the world is just moving super fast. So we're going to try this new thing. We're not going to get in the way of local governments who want to try to adopt these things to get out in front of what they think are going to be all of these impending nuisances. And if you reconcile that sort of, that view from the court with what we now know, I think you can say, well, the court was wrong to just, give the local governments carte blanche, because as we've come to learn, zoning was actually counterproductive. It doesn't foster health, safety, and community. It undermines all of those things. But that's going to be a huge evidentiary showing that you're going to need to make. And again, that implicates the rational basis test, which is, when the courts, which is a test in which courts say, well, evidence doesn't really matter that much. So it all sort of ties together. We need courts to recognize and seriously weigh and review evidence if you're going to convince it that circumstances have changed and that the information on the ground is different, such that you should change your mind.
What was the decision that overturned Roe?
Dobbs?
The Dobbs decision. Like,
Yeah.
why did they? My understanding prior to that was like, they're not going to mess with Roe because it's been around for a long time, and what was to the point of like, have circumstances changed?
So
how did that come about?
Yeah. So in my response to your first question, I talked about there, a couple instances where they would do it, and I started talking about changed circumstances. The other way, and this is what I think was primarily happening in Dobbs, is an acknowledgement by the court that this was badly wrong on the day that it was decided. And whether, there's new information or facts have changed in a scenario like that one, the court has said, well, even if the information is the same or the facts are no different, this was egregiously wrong the day it was decided, in the words of Justice Alito. And so that's the reason for retreating from precedent there.
Is that how they? I think you said maybe it wasn't, but for the Brown versus Board of Education decision over Plessy, did they not? Were they like, conditions have changed, we now know better, or were they like, no, that was wrong back then?
I think it was a combination of those things. I mean, based on the changing conditions and we now know better, we now know that it was wrong for us to have thought what we thought when we decided Plessy. I don't think there's any, a lot of lawyers will disagree with me on this. Judges
That's what y'all do for a living.
I know. Judges get things wrong all the time. And I understand the importance of everybody living in a legal environment in which, there are consistent rules that we all know and understand and apply. But it's also critically important to get it right after you've gotten it wrong. And so, maybe the pace of change when doing this is a little bit slow, and it has to be incremental, and you don't want all of these major disruptions. You don't necessarily want, if you're a lawyer or a scholar or anyone really, maybe you don't want a Dobbs every term, whether you like the outcome in Dobbs or not, these paradigm shifting, shifts in direction. If maybe you don't want one of those every term, but I think it's still critically important for courts to get it right. And that is especially true after they've already gotten it wrong. 2 years after Euclid was decided in a case called Nectow v. Cambridge, the court takes up what was essentially a near identical zoning restriction passed by the town of Cambridge, incidentally, which is now undoing its longstanding zoning to allow for all sorts of new development. And the court there struck it down under basically the exact same standard that it used to uphold the zoning restriction at issue in Euclid, saying this would destroy the investment-backed expectations of the property owners. If you look at the surrounding area, this area is, makes total sense for there to be some light industrial use here.
This is the same justices.
This is an opinion written by Justice Sutherland just 2 years later. So, going back to the discussion about, well, what swayed the court in Euclid and why did it seemingly shift the outcome? It seems a lot like there was just some, good old boy business going on in Euclid that led to the alteration of the outcome there. And 2 years later, you have another opinion striking down a zoning ordinance. And then not a lot from the courts on zoning for a really long time until 1973. You get to a case called Belter v. Boris, which I think we have talked about this offline, is really the decision that blew the doors off of zoning as we know it and basically opened the door for all kinds of nefarious business.
Right. It enabled municipalities to get much more technocratic. Is that right?
I think that's right. What was at issue in Belter v. Boris was a restriction on the number of unrelated people who could live together in an existing single family community. And you would think, well, that's a completely private, intimate decision that people ought to be able to make for themselves without government getting involved. And the court there said, no, it's totally legitimate for government to regulate in this way, because not only are we regulating use, but we can regulate what are essentially vibes and the nature of a single family neighborhood, the quote unquote blessings of quiet seclusion. And the court spoke in very, very lofty terms about the aesthetic beauty of the single family neighborhood and how idyllic it is, in a way that I think is totally disconnected from the average lived experience of most of Americans who didn't grow up in some bucolic single family neighborhood. But that's where the court basically said, hey, you can do whatever you want to local governments, and the courts aren't really going to get involved. And that is why, to this day, when folks like myself bring zoning cases, especially in federal court, sometimes the challenges are met with hostility from judges who think the judiciary has no business getting involved in cases like these.
What year was Belter?
1973.
Yeah. Well, why do you think in the 1928 decision, say that the name of that again?
Nectow v. Cambridge.
Nectow?
Nectow.
Yeah.
V. Cambridge.
Okay. Nectow. So why? I know I'm not a legal scholar by any stretch, but I feel like I know more than the average bear about real estate related legal decisions. I don't know anything about that one.
It doesn't get talked about nearly enough. How did it come out differently from Euclid? What is the logical legal explanation? I couldn't tell you. Mm-hmm. And maybe there are some people who are smarter than me who have a bulletproof explanation and understanding for why those seemingly inconsistent decisions exist and why we only seem to follow one of them. But it beats me. I think we shouldn't be talking about Euclid without talking about Nectow. And we shouldn't be talking.
How is it that two, are they conflicting decisions? How do they both?
Well, they purport to apply the same standard. And I think what you had in Euclid, if I'm going to try to come up with an explanation myself, is the court saying, well, there's a lot of evidence here that, this is necessary. There's a lot of experts. A lot of people have submitted reports. We've got all of this, data in front of us, or what they thought was data in front of them.
And some well-connected political players.
And some very well-connected political players to suggest that this is, sensible. Whereas in Nectow, I think that quantum of evidence was absent. But what that tells me is that evidence matters. And it should matter in any case. And I think we shouldn't I said we shouldn't talk about Euclid without talking about Nectow. I don't think we should talk about either of those cases without acknowledging that in both instances, the courts acknowledged evidence and they said there should be a substantial connection or there should be a substantial interest on the part of the government. And reconcile that with what courts say today, which is much softer in terms of the necessary evidentiary burdens and the nature of the government's interest. So I think even if we were to relitigate Euclid today, we would be arguing that I think zoning cases today aren't judged with the same evidentiary standard and burden that you see in Euclid. And I think it's critical for us to actually ask courts to consider evidence when weighing zoning decisions, which I think is what the court said should be done in Euclid and in Nectow v. Cambridge after, but courts don't do today.
God, I have to look more into that. That's fascinating. I still can't understand how these decisions, which seem conflicting, can both. How can there be two decisions that are conflicting? I may be asking kind of a dumb question or totally.
No, you're not. I think I think a fair reading of those two decisions is that they're just irreconcilable with one another. And I think if you're going to reconcile them, the way to do it is to say, well, Euclid says you can zone if the evidence suggests that zoning makes sense, and NECTAO, maybe doesn't mean that you can't zone. It just means that, again, you can zone if the evidence suggests that it makes sense. And here the evidence suggests that it doesn't make sense. And I think that they try to draw the distinction on the facts. And I think if you look at NECTAO, I'm pretty sure that the Supreme Court in NECTAO, again, it's Justice Sutherland, I'm pretty sure he says, we're not overruling Euclid. This is totally consistent with what we said in Euclid, even though it looks like it's totally inconsistent with what we said in Euclid.
Sounds like there's definitely some stuff going on in the background.
Yeah.
It would be amazing. I would be just totally astounded if that ever happens and affects how legislation passes or how laws get made. But I guess maybe it's possible those things happen.
I was thinking about the timing of these decisions, 26 and 28. And then, I wonder, had not there been the Great Depression and World War II, there might have been more challenges, but the building really didn't start again, house building and everything, till, there was some building for sure, but it didn't get started in a big way till 1947. So by then it was like zoning was just kind of commonly accepted as, well, that's the way we do things, and you skip the generation and that's something different. So I wonder about that.
Yeah, and there's also a general, some of these cases were still going on at the state level. I think what you saw after Euclid and NECTAO to a certain extent was the federal courts basically just saying this is a decided issue at the federal level. And so if you want to litigate this, maybe push it down into the state courts. And I think that's also what's reflected in that large time gap is the Supreme Court in particular saying, we don't need to address this. We've decided it. This is constitutional, and this is a local issue, which they tend to not like to get involved in.
That was certainly a period of time too, where I think just people in general had an enormous amount of deference and institutional trust and deference to like, well, I guess if they said we need to do this, then we probably need to do that.
Yeah. Yeah. And for a long time, and even still today, there are a lot of people who just think, well, everything should just get pushed down to the local level. And that, makes sense if you have a ton of faith in the ability of local officials to respect your freedom.
Well, I'm a passionate localist and subsidiarist, and I would say the most local level for decision making is me.
So there's that.
Yeah, it's yes, I am going to decide what to do with my property.
I think all things being equal, localism for me kind of wins, but all I really care about is liberty. And so I don't get up in arms when a state government passes a preemption bill that restricts local government's ability to harm people.
Yeah.
This is going to get back into the transportation thing too, because I think that clouds the issue, and you're using federal dollars to expand out into the middle of nowhere. And thus you can say, okay, well, we don't need to accommodate this working class. They can just go live somewhere else and drive in.
It relates to transportation, and we hopefully we'll take this up in an additional one, but it's a big topic. It's not just federally funded indiscriminate expansion of infrastructure to promote the development of the hinterlands, but it's also enabled by it's federally financed. It's debt fueled expansion of infrastructure, which is paid for by people who are not yet born. Maybe Vince, do you? I know it's very painful for you to ever interrupt. Do you have any questions you want to chime in on? Because I'm gonna, if not, I wanted to shift to maybe what's happening today in the world of zoning from a legislative perspective and how that does or doesn't relate to what's happening in the legal world on zoning.
You go ahead. I won't interrupt the flow.
Okay. Well, maybe might have been my last episode of Yeoman spoke with Emily Hamilton I had a great conversation with her, Ari. I know, well, both you and Vince know Emily. And we talked about the kind of largely the rate of change from a legislative perspective, both at the state level and the municipality level, and how cities and states are looking at zoning and wanting to tending to the direction is there's not a whole lot of cities that don't have zoning now that are thinking about implementing it. And there's a lot of cities that have it that are aggressively neutering it. And the same at the state level. I can't remember if it was before we hit record or not, but you kind of made the reference that is happening, and it's also happening at a bipartisan level. There's enthusiasm both among conservative and liberal leaning people. How do those? My view is, or I imagine that some of those legislative changes are happening because states or cities are recognizing the regressive nature of not only the financial burden that it creates, but the regressive nature of some of their zoning policies, and think that they might be opening themselves up to that the court might force a change if they don't bring about a change legislatively. Do you have a point of view on that?
I'm somewhat skeptical that they're doing it because they're worried about courts entering decisions that are going to force it upon them. But I do think there's just enough political pressure from constituents who want this, who know this needs to happen. I also think we should break them up in state reforms and local reforms for a couple of different reasons. I think local reforms are critically important because that is primarily where most zoning is done. It is the origin of most of the problems that we see that are created by zoning, like high living costs, inability to open a business, and things like that. And I think those localities that are making changes are being responsive to demand from people within their communities to bring down the cost of living, to make it easier to open a business, and once one starts doing it, then another has to stay competitive, and you get this sort of snowball effect going. I think that's really, really important that it be done at the local level. At the same time, local government has, for the most part, historically been super recalcitrant when it comes to making these types of necessary reforms, or is only doing reforms at the margins that aren't really ultimately being all that helpful. You have a lot of opposition at the local level coming from, like, quote unquote NIMBY groups that restrict or that rally to impair and stop new development and changes to the code that would allow for things like infill. And that's where I think statewide reforms come in, because when you aggregate, this hyper local mentality that nobody should be able to build anything anywhere across an entire state, well, now you have a state that has a severe housing shortage and crisis. And the only way to bring local governments in line, if they're unwilling to, open their doors for change, is to do it at the state level. And so I think Montana has been a really good example of a state that's done that. But there are also some really good local examples. But I think, to your point, I think the all of the above approach is necessary. I hope reforms from the courts are coming soon. But I think the courts, the judiciary, tends to be downstream from culture, legislation, judicial action.
Have any of these changes, say Montana or California, or on a municipal level, Cambridge had some pretty dramatic changes recently.
They just did away with single family zoning, I think.
Yeah, they did, and enabled by right development. They still have zoning, but it's by right. I think 4-story multifamily without density restrictions.
Yeah, incredible.
And I think up to, in some areas, 6 or maybe 8. I can't remember, but it's dramatic. Essentially enabling. And people, I read a lot of accounts like, oh, this is crazy. This is going to be terrible. I'm like, yeah, they might, build Paris, the most beloved parts of Paris or Rome. Like,
Yeah.
Maybe that would happen.
Yeah.
But have there been pushback to those reforms, legal pushback to those reforms? So kind of people who oppose liberalization or neutering of zoning,
Yes,
are bringing suits.
Yes, absolutely. And so that might have been a better answer to the question you asked before. I think one thing slowing some of these reforms at the legislative level could be the fear of being sued by groups that are resistant to the reforms. This is exactly what happened in Montana. An organization called Montanans Against Irresponsible Densification filed a lawsuit challenging the reforms that Montana passed about a year and a half ago now, which would have done things like allow duplexes by right, ADUs anywhere. And that group, interestingly, brought a challenge saying that their constitutional rights were violated, that they had actually suffered a taking and an equal protection violation as a result of their property rights and their neighbors' property rights having been enhanced and afforded greater respect.
Can you allow, like, that argument? I hear, I hear people, I talk about this a lot, but people will say, like, how would you like it if your next door neighbor could be able to just build a high rise? I'm like, I don't know, land where there's demand to build high rises is pretty pricey. Yeah. I think that would be good for me if I was able to do that. Like, what is the taking argument for you can do more with your land now? So you've been robbed of something.
In my view, there isn't one. And as somebody who knows about takings law and constitutional law generally, I think it's a totally bogus argument. And we submitted an amicus brief to the Montana Supreme Court basically telling them as much. Mm-hmm. It's very reminiscent of participants and government-created cartels bringing, if you think about like the taxi medallion cartel, I don't know if you're super familiar with that, but these were medallions that allowed you to own and operate a taxi cab, and they were worth hundreds of thousands of dollars in some places because the market was intentionally stifled for the benefit of taxi cab companies. And then when Uber came, into the marketplace, and the government said, all right, we're going to just dissolve this cartel, some of the taxi cab companies filed lawsuits saying, well, this thing that I thought was worth hundreds of thousands of dollars is now not worth anything. And the answer is, well, you don't have a constitutional interest in a government-created cartel. And so you haven't been subject to a government taking. And we won those cases, or we were right about that when courts decided those cases. I think this is an even more obvious example of someone not having a constitutional right, because not only is your property not decreasing in value, which did in fact happen if you had a taxi medallion, but here, when your rights expand and you can do more with your property, you're right, it's worth quite a bit more. And so you can't even point to any actual property interest that's been impaired or a loss of value that you've suffered as a result of the reform.
Tell me, I'd like your take on this. This is maybe directly relates to the taxi medallion thing. If you are the transnational RET, whatever, if you're the only owner of land in a city that is zoned for multifamily, if you're the only property owner in that town that has the right to develop apartments, and the town then extends that right to anyone, and whereas you had planned to build a 400 unit apartment building on your one property where that's legal, and then everybody in town can all of a sudden, where they were previously only allowed to have a house on their property, they might have an 8 unit, small scale, missing middle neighbor. Like, I would think that would negatively impact your value as the one who holds the medallion. You would no longer be the only one who can serve the apartment market.
Yeah, but in that scenario, I think it is just like what you described, or what I described before, in that you can't articulate, in my view, in my understanding of the takings clause, a property interest in a government-created monopoly. The owner you're describing is a beneficiary of a government-created monopoly. Right. It's a totally illegitimate marketplace, and there are some people who, these do exist and there are people who benefit from it. But when the government levels the playing field in a way that enhances the property rights of other people to at least bring them on par to where you're at, I don't think that there's any basis on which you can say, hey, you've taken my property. What has been taken? You can still build what you wanted to build. The free market might not treat the value of the dirt in quite the same way, but I think it's an instance of investment-backed expectations. And is it a legitimate investment-backed expectation that I will forever, for all time, be the only person who can exercise my property rights in this way?
Were there court challenges for do you know, this may be outside of your area, for the taxi medallion type thing?
Yes. So the taxi medallion owners said this is a taking. We had a property interest in this thing. As a result of government action, it is now worth less. And so therefore, you owe me money. It was a taking without just compensation. And IJ filed amicus briefs in those cases saying these are not takings because your interest is one of a government created monopoly. It was illegitimate to begin with. It prevented other entrants into the marketplace who would have wanted to do the thing that you were exclusively allowed to do. And when finally those people are allowed to do that thing because their constitutional right to do that thing exists, you can't come into court and say, okay, now pay me. So I think, it's a specious argument, but it's still a creative one. More so, they're being litigated on sort of picayune procedural grounds. This is happening, I know, in Virginia, in Arlington. I think it happens all the time in places like California, New York, where as soon as the reform passes, a group comes in and says, well, you didn't do the necessary multi-layered environmental reviews that you were supposed to go through before passing this. And so you've got to go back and do those. That is typically the biggest or most common, I should say, variation of post-reform litigation that we see.
When I hear you describe the defenses of the status quo, and of course I have my biases, and I know you do too, but they sound like on their face ridiculous. And is it like the attorneys who are having to argue to perpetuate the taxi medallion system? Or is it just ridiculous to watch them? I would imagine it's do they know they're ridiculous? So
they don't. I think they know they're ridiculous, but they've also had decades of getting away with ridiculousness, behind them as wind in their sails. Because those are the same, we talk about the taxi medallion groups, those are the same organizations that pushed for regulation on regulation for decades that made it near impossible for any competitors to enter the market. And when you look at how that works sort of in the zoning and housing realm, these are special interest groups of homeowners who for a really long time have had their say in city hall and at state houses and stopping new development from coming online and new housing from being built. And so to them, I think this is just a continuation of that campaign. It also, I think, turns a little bit on your conceptualization of property rights and what it means to own property and have property. If your view of property ownership is that I own this thing, it will remain this way forever, and anybody who does anything else on their property somewhere else is going to affect me in a constitutionally injurious way. If that is what you think the Constitution protects, then sure, you're going to file a lawsuit. You'd happen to be, doctrinally and factually wrong. But I do understand, although I don't agree with the mentality of some of the people who are filing these lawsuits, because they've had decades of wins on this stuff.
Well, it says the whole Upton Sinclair, hard to get a man to understand something if his salary depends upon him not understanding it.
Very true.
It just seems like so flagrantly un-American, just at its core, and I think a lot that happened in the progressive era and the aftermath of World War I, that, and also World War II, just was we look, if you're kind of trying to embody the American spirit and think about everything through that view. You're like, God, that's crazy. Why would we ever do things like that? I'm reminded a bit when you were talking about kind of the proceduralism and things. I'd love to get your take, both of y'all's take on this notion of Ezra Klein and his co-author Thompson. Forgive me, co-author. I'm blanking on your name, but the abundance case and what relationships that might add to it. I haven't read the book. I've listened to a couple interviews, but I recall I think it was Klein doing an interview with Jon Stewart. Maybe this was really early on, and he was essentially describing what needs to happen in order to build something. And it's so funny to of course, in the building industry, we have these conversations all the time. Like, we know how ridiculous it is. But Jon Stewart clearly had never, he didn't have to file a permit application to write a joke. So it's like he didn't, you don't really understand it. But when Klein was describing this, you could, Stewart's head essentially exploded. He could not conceive that things might be so procedurally difficult to build something. But anyway, so I have some critiques of what I see as, I say this without having read the book, so that's not good. But what I see is in the abundance movement in general, though, I see the rising awareness among kind of center left people that hey, this is how it is not good. I see that as very optimistic for the work that you're doing at IJ and that we're trying to do as builders of things.
Yeah, Vince, do you want to? I know he invited us both to jump in on that one.
In terms of timing, I think about something Ari said a couple times about politics, or that is the courts and legislation or politics being downstream of culture, and so the culture, I feel like in a lot of ways is in turn downstream of the environment. And that includes the economic environment. And when it becomes pretty clear that all this whole segment of the population is, been crowded out of opportunities to simply live in a place, it becomes really hard to deny. And it just this builds up. It's almost like I feel like it's a bit. The situation is not unlike the civil rights movement of the 50s and 60s, where you had this kind of mindset that was locked in, but then all of a sudden, or not all of a sudden, but over time, people realize, well, this is un-American. This doesn't work. And so, if you have these. And I was thinking too, Ari, about some of these cases that you're describing in Georgia. It's almost like you're having these Rosa Parks moments on the bus, and like these people who otherwise can't start a little business or whatever. It's like, you just elevate them, and all of a sudden people see and they're like, what the hell? And I mean, you and our friends, Nolan Gray and Sonia Trouse and all these people are just really seeing this and like pushing it and compelling people to talk about it. So it's a little bit off track, I guess, from what you asked, Geoff, but I just see this fitting into.
I think it totally relates to that, or how the abundance folks are responding to that situation. Go ahead, Ari.
Well, I think to your point, Vince, IJ selects its cases and its clients, in large part based on the model of the NAACP. And that's not to liken our movement to the civil rights movement. But there are parallels that you can draw between promoting liberty and property rights and the civil rights movement of, the 40s, 50s, and 60s, and even a little bit beyond. You need people who are good advocates for a cause, who can be articulate, who can represent an issue well, and who can get people who were sort of stuck to a certain set of ideas to rethink those ideas. Those people sometimes have to be judges, and judges tend to live, to bring it back to what we're talking about, they tend to live in single family neighborhoods. They tend to be very well educated, somewhat privileged people who don't really have the life experience of someone who maybe had to commute an hour and a half to get to a low paying job. And I think bringing all of those people, into the tent to understand why this is hugely problematic is always going to be challenging. But to Geoff's question about, Ezra Klein's book, I think one thing that we can all unify behind is that, like, hey, there are some major problems out here. Here are some obvious explanations for why we have those problems. And like, these are all things that we should be able to agree on. You're seeing it at the state and local level with bipartisan support for zoning reforms. And, I think in America, barren shelves are intolerable in any marketplace. And I don't think housing should be an exception to that. And for a really long time, we've just kind of accepted that, well, we generally have, loads of options when we go to the grocery store or a department store or the dollar store to buy whatever we want, because all kinds of different products are on the shelves at different price points. But for some reason, for housing, we've just accepted that isn't the reality. And it's our own doing, and we need to undo it. And I think that book, from what I understand, again, I haven't read it either, although I'm pretty familiar with its thesis. I think that book is a sensible call, especially, you're right, Geoff, to left of center people who thought, hey, we've thought, going back to the discussion we started with about progressives and, the idea that we could just plan these perfect communities and societies. Some of these things could be rooted in the best of intentions, but we know about what the road to hell is paved with.
Yeah. Well, what do you see happening? What are things that you're excited about? Maybe this is a good way to wrap up at IJ.
I'm excited about our work in the Zoning Justice Project. I think this, what we're doing here is a multidimensional campaign, both in the court of public opinion, through state houses and city halls, and of course in the courts, to bring about reforms that I think are going to be helpful in solving some of the problems that we have today. This is a long-term campaign. And we're hopefully building toward the type of monumental change that we've discussed here today. But in the meantime, I think it's really important for us to continue to stack small. I don't call any victory a small victory, because every victory is a component of something hopefully bigger. And that's what we're working toward, both with legislative reforms and with our court cases. I'm really excited about the fact that this is now a mainstream topic. When I went to law school, graduated in 2009, and I was one of few people who had any sort of an interest in land use and environmental law. And it was considered like the driest topic for the nerdiest of nerdy people, which I always resented, because I thought this is real life. It's really cool. You're like, hey, I was law school cool. I will say that. I like to think that. But it's always struck me as odd that it was such a sort of not esoteric topic, but one that people didn't take an interest in, because to me, this is something that governs our everyday lives, whether we like it or not. And how do you just, find that to be boring? But anyway, like I said, it was considered boring. It was unpopular. It was not a cool thing to talk about. And now everyone's talking about it, which is really, really awesome. It validates, I think, a lot of what folks like me have been saying, and what organizations like IJ have been saying for decades. Because this is one of those areas where you hate to be right, but I think property rights advocates undoubtedly are right and have been right about this for a really long time. And it's very, very cool when you see a lot of people, including those who are left of center and even way left of center, saying, "Hey, this is a huge problem. We've got to fix it."
Yeah, if anything, I'd like there to be more enthusiasm for the notion of property rights among people who are center right and far right.
Yeah,
and I think it's interesting to me that I think maybe the libertarian kind of lowercase L libertarian movement is sort of coming around to this in a big way, but they were late to the party, I would say. I am, as you say, like, I think it's really exciting time because there's so much enthusiasm around this topic, and people who would advocate for the status quo, or who have been advocating for the status quo, had been for as long as I've been paying attention to these things, now more than a few decades. They had been they've been the prevailing forces, but now those people are very much back on their heels and trying to craft strange, kind of ridiculous defenses for perpetuating the status quo. And it just feels to me, both legislatively and legally, that the times are changing, and they're changing fast.
Yep.
Well, I would like to direct people to learn more and support IJ. Can you tell us where they can find you and where they can find the work of you and your colleagues?
Sure. You can find us on the web at www.ij.org. That's the best way to find me and to learn more about the Zoning Justice Project. There's a tab there on the right, which will take you right to our page, but I think it's www.ij.org/zoningjustice with a hyphen between zoning and justice if you want to come right to the landing page.
You can find Vince's company Loci on the web at it's LOCI, Loci, LOCI South.com, and see a lot of the work that Vince is involved in, including some of the things we worked on together. Thank you both. Any closing words for us?
This is really important, and I'm excited, Ari, that you're at the forefront of this. Are you 40 yet?
I'm 40. I'm 42 in 3 weeks.
Okay. I think this too. I mean, I know you're standing on the shoulders of some giants, but I find it interesting, and it's the timing of this. So many people like yourself are, relatively young. So I think I'm just very encouraged and enthusiastic about the next few years.
I love that point, Vince. It's like the people that are defending the status quo tend to be pretty old,
mm-hmm.
and yet the people that are in this fight for the long term, the decades to come, have decades more fight in them. It's pretty exciting to me. Well, gentlemen, thank you both. Thank you for joining me on Yeoman. And I hope to talk to you guys again soon.
All right. You're welcome. Thanks. Good to see you, Ari. Geoff. Bye.
Likewise, gentlemen. Bye-bye.